The Offensive Weapons Act 2001, 18th of June. Section 1, short title. This act may be cited as the Offensive Weapons Prohibition Act. Section 2, interpretation. Subsection 1. In this act, ballistic knife means a device or instrument designed or adapted to fire or discharge a knife, dagger, or similar instrument by a mechanical, percussive, or explosive means. Butterfly knife means a knife with two-piece handle which floats together to cover both edges of the blade, where the blade is not serrated and exceeds 7 centimeters in length. Dagger means a sharp-pointed stabbing instrument ordinarily capable of being concealed on the person and having a flat blade exceeding 8 centimeters in length with cutting edges, whether or not serrated, along the length of both sides, and B, a needle-like blade, the cross-section of which is elliptical or has 3 or more sides, but does not include instruments such as swords or bayonets. Flick knife means a knife designed to or adapted so that the blade is concealed when folded or recessed into the handle, and which opens by gravity or centrifugal force or by any pressure applied to a button, spring, or device in or attached to the handle of the knife. Knuckle or knuckle duster means a device or instrument designed or adapted to be worn across a knuckle or knuckles of the hand, fingers or thumb, so as to A, increase the force or impact of a punch or blow when striking another with that hand, fingers or thumb, or B, protect the knuckles or knuckles from injury when striking another with that hand, fingers or thumb. Knuckle knife means an open or exposed blade or similar instrument attached to a handle that is designed or adapted to be held between the knuckles, including the device commonly known as urban pal knife. Offensive weapon means A, any article made or adapted for use for causing injury to the person, or which is intended by the person having such article with him to cause such injury. B, any dagger. C, any sword stick, ballistic knife, butterfly knife, flick knife, knuckle duster, knuckle knife, or any knife which is commonly known as a switchblade, ratchet knife, or Rambo knife, or such other knife as the minister may prescribe by order, subject, or affirmative resolution. Public places includes every highway, road, or other passageway, court, parade, wharf, school, premises, public garden, open space, or any place used for the purpose of sports and games, and B, any other place or premises to which at the material time the public has access, whether on payment or otherwise. Switch or sword switch means a cane, stick, or similar article designed or adapted to hold the blade of a sword so that it is concealed from view until withdrawn from the cane, strike, or article. Section 2. Subsection 2. Paragraph A of the definition of offensive weapon and subsection 1 does not include any of the following substances that a person has with him for personal protection, namely mace or pepper spray. A, that's A. B, such other substance as the minister may prescribe by order subject to affirmative resolution. So the Act does not regard mace or pepper spray. It doesn't include it in the definition of offensive weapon. Alright, we continue. Section 3, subsection 1. Section 3, offenses of carrying an offense of carrying an offensive weapon in a public place. Subsection 1. A person shall not, without lawful authority or reasonable excuse, knowingly have with him in any public place any offensive weapon falling within paragraph A or B of the definition of offensive weapon. Subsection 2. A person shall not knowingly have in his possession in any public place any offensive weapon falling within paragraph C of the definition of offensive weapon. 3. A person who contravenes subsection 1 or 2 commits an offense and is liable to summary conviction before a resident magistrate to a fine not exceeding $4,000 and in default of payment to imprisonment for a term not exceeding 4 months. So it seems like what this is saying is that if the police sees you with a knife in a public place, they can arrest you and you can be brought before a resident magistrate to pay $4,000 or spend 6 months in prison. Subsection 3. A person who contravenes subsection 1 or 2 commits an offense and is liable on summary conviction before a resident magistrate to a fine not exceeding $4,000 and in the that's what I read already. Subsection 4. It shall be a defense for a person charged with an offense under subsection 1 to prove that he had the article with him for the purpose of any lawful sport or the person's lawful trade, business, or occupation. Subsection 5. A constable shall A. seize any offensive weapon referred to in subsection 2 which is found in the possession of any person in contravention of that subsection. So they can take away your knife. B. Seize any other offensive weapon in respect of which he has reasonable cause to believe an offensive weapon or an offense has been committed under this section. And that weapon shall be detained by the constable until such time as any legal proceedings in respect of the offense are finally disposed of. Subsection C. Where any person is convicted of an offense under subsection 1 or 2, the court may, upon the application of the prosecution, make an order for the forfeiture of any offensive weapon used in the commission of the offense. So, order for forfeiture of any offensive weapon used in the offense. That means they can take away that offensive weapon from you and not return it. It seems so. Remember, I'm not an attorney at law, but we want to discuss what the law says. We continue. Subsection 7. A conviction under this section shall not form part of a criminal record of the person convicted. Okay, so if you're convicted of, well, what they seem to be saying is that if you are convicted of carrying an offensive weapon in public, that conviction will not be recorded. It will not go on a criminal record. All right. Section 4. Procedure upon forfeiture of offensive weapon. Subsection 1. Where the prosecution proposes to apply for forfeiture of any offensive weapon under Section 3, 6, notice of such intention and of the grounds thereof, therefore, shall be given forthwith to any person who, to the knowledge of the prosecution, is the owner thereof. So they will have to make you know that they are going to forfeit your offensive weapon, provided that notice shall not be required to be given under this subsection if the seizure was made in the presence of the owner of the offensive weapon seized. All right. Subsection 2. Without prejudice to any other form of service, notification may, for the purpose of subsection 1, be made by 2 publications in a daily newspaper printed and circulated in Jamaica. The second of such publication not later than 3 days after the first. So you mean they can actually publish that in a newspaper that they're going to seize your offensive weapon, as the law calls it. Subsection 3. Any person having a claim to any offensive weapon in respect of which an application for forfeiture is made pursuant to Section 3, 6, may appear before the court on the hearing of the application and show cause why an order for forfeiture should not be made. Subsection 4. Where, on hearing of an application pursuant to Section 3, 6 for forfeiture of any offensive weapon, no person appears before the court to show cause why an order for forfeiture should be made or should not be made, the court shall presume that such weapon has been abandoned. So if they publish that you're going to seize, you're going to take away your knife, or they have seized a knife, a particular knife, from a premises, and you believe it is yours, but you don't turn up in court, or then they're going to assume that you have abandoned the knife or whatever other offensive weapon there is. Section 5. Subsection 5. If upon the application of any person aggravated or aggrieved by an order made by the court under Section 3(6), the court is satisfied that it is just to revoke such order. The court may revoke that order upon such terms and conditions as it deems appropriate, and without prejudice to the generality of the foregoing, shall require the person to pay in respect of storage, maintenance, administrative expenses, security, and insurance of the offensive weapon, such charges as shall be approved by the court. So they seem to be saying that if you are the owner of the offensive weapon and the court is satisfied that they can revoke the seizure of your offensive weapon and hand it back to you, you must first of all pay them money, pay the court the cost to store and maintain the offensive weapon, administrative expenses, security, and insurance of the offensive weapon. Well, what amount of money would that be? Probably you would just abandon it because it would be more money than buying. It would cost more money to do that than buying a new one. Anyway, 6, subsection 6. An application to the court under subsection 5 for a revocation of an order shall be made within 30 days of the date of the order, or within such greater time, not exceeding 3 months, after the date of the order as the court may allow. Section 5. Power to search and arrest without warrant. Subsection 1. A constable may, in any public place, upon showing his proper identification as a constable, search without a warrant. A. Any person whom he has reasonable cause to believe to be in possession of any offensive weapon in contravention of Section 3, or anything carried by such person. B. Any vehicle, its driver, and any passenger, if he has reasonable cause to suspect that an offensive weapon is to be found in any such vehicle or on such driver or passenger in contravention of Section 3. Subsection 2. If in the course of any search carried out pursuant to subsection 1, an offense under Section 3 appears to have been committed, A. The constable shall seize any offensive weapon found in the course of such search. B. The person shall give his true name and address to the constable when requested to do so. C. If the person fails to give his name and address, the constable may, without warrant, arrest that person. Section 6. Regulations. The minister may make regulations generally for giving effect to the provisions of this Act, and all such regulations shall be subject to an affirmative resolution. So, that is the Offensive Weapon Prohibition Act.